Karen Reed, Canton.
All right.
It's the case that just won't stop. We know the next trial date's April 1st, but there's so much going on, and in this case, coming up Friday, this is the reporter who's arguing that the notes she took, private notes she took during the interview of Karen Reed, should not be discoverable. So let me hit the procedural
Okay.
landmarks here for you to tell you where we are in this. Obviously, Karen Reed accused in the death of her boyfriend, John O'Keefe, ended up in the snow that night, almost exactly 3 years ago. In fact, I think it's
Wow.
3 years ago, day after tomorrow. Anyway, and dies by exposure, but how did he get there? That's really the big question. How did he get in the snow that ended up killing him? So on the 5th of December, the court grants access to the notes. There was an original request by the prosecution. We want those notes. And then there was, of course, an objection to it. But on 12/5, the court said, nope, those notes are available. A month later, on the 7th of this month, Gretchen Voss, who is the interviewer, the person who wrote the article for Boston Magazine, she filed a motion for reconsideration. Now, generally, tell me your experience. My experience with this, Linda, motion for reconsideration is like asking your mom a second time if you can stay up late. She already said no. So why is she going to
Right.
change her
Right.
mind, right? So this is a motion for reconsideration is generally, and I think it's universal. It's heard by the same judge in the same department that denied you the first time. So that's
Right.
the
Right.
framework.
Motions for reconsideration are usually, let me put it this way. You want to talk about coaches who could coach to a successful Super Bowl team? I mean, it's kind of like probably less, right? Right? Yeah.
Yeah.
In terms of winning them. I'm just going back to my Jets. What can I say? I'm
You wish you
thematic.
had Andy Reid. Anyway, so that's the framework, and sometimes it's done purely to give yourself the opportunity to appeal if you really want to do that. Because once that reconsideration motion is denied, as they most often are, then you take it up on appeal. It'll be interesting to see if that happens here. Remember, we still have the juror issue on appeal, and we're assuming it'll be resolved by the April 1st second trial date. We don't know. And if that doesn't get resolved, you can count on that second trial date, April 1st, being
Right.
pushed as well. Okay, so they're going to get together. The court agreed to hear the motion for reconsideration. The notes, the actual notes, were turned over on the 15th in camera. So the
Of
judge or the court has
January.
those.
January?
Yeah, just what is that? 10 days ago, 11 days ago.
Yeah.
So the court has those now and has been looking at them and will use those notes. It's kind of weird. It's like if there's anything in the notes that matter, the court's going to allow their discovery, right? And if the court decides that there's really nothing of importance, maybe the court will ultimately grant the motion to reconsider. It's hard to tell. It's very hard to tell, but it depends on what's in those notes. Here's what I think is interesting. Here's where those notes come from. If you haven't read the article, it's a decent article. It's it's in Boston Magazine. All these articles I've read, about true crime, they try to read like a Truman Capote, In Cold Blood novel. They try to smush them up a little bit so it's more dramatic and it's not just here's just the facts, ma'am. So it's a nice article. And Gretchen Voss interviewed Karen Reed twice. Okay. She interviewed her the first time, June 30th of 23. She interviewed her the second time, July 13th of 23. Both of those times, her attorneys were present. Karen Reed's attorneys were present during those interviews. Okay.
Okay.
There were notes, a lot of notes, and audio recordings were already provided. And then the prosecution said, no, we want more because there were redactions, both in the notes and in the audio. So now they're coming back saying,
Okay.
look, we want the unredacted. And so don't cry that, oh, it's a lot more work. We have to bring you how can it be more work to give you the unredacted than the redacted? So from the defense perspective, that's a horrible argument. So give the prosecution the unredacted. That's what they want. I don't think it's the notes they care about from those meetings, 30th of June and the 13th of July, because the attorneys were there. And
Right.
I can guarantee you they protected their client if she started to stray, right?
These are
But
good attorneys. Absolutely.
there was an interview without the attorneys at Karen Reed's home, and the date I'm uncertain of. It was a third meeting, and I think it had to take place after July 13th. That's just my speculation. But I do know it was just her and just Ms. Voss, and notes were taken. And that's all that was taken. No audio recording of that meeting. Those are the notes that I believe the prosecution thinks are going to have the smoking gun. And what they're looking for, obviously, are inconsistencies with what we've learned from trial number one and what we, in theory, have learned from the discovery as we head into trial number two. Primarily, dun dun dun, did Karen Reed acknowledge running into John O'Keefe? We already know, you know the whole story from the scene,
Right.
right? I hit him. I hit him. I hit him. I hit him. I hit him.
Never in any,
You
but
know,
never in any police report. Never in any of the people that said she said that in the reports.
except for
And
her friends who
yeah,
were very clear that she said that.
yeah,
And
yeah.
of course,
But even those friends' admissions weren't in the reports.
so the question became early on, was it a question like I hit him? Like she's
Right,
putting
right.
it through her mind, or almost like she assumed I hit him because okay, doesn't mean she did or didn't, but she
Okay.
at least was giving it some thought.
Well,
So
Bob, you know how Bob Bianchi likes to talk about when he was a baby prosecutor or whatever.
he does that.
What?
Yes.
Yeah, he does that. It's really when I was a baby law graduate. I got a job, and it was a big job. It was being the law clerk for the presiding judge of our appellate division, which is under New Jersey, the trial court, the appellate court, and then we have the Supreme Court. We are Supreme Court's the top, as in most states, right?
Yes.
And I was, he was the judge. I mean, he was in charge of all the other appellate judges, and we shared an office with a Supreme Court justice and another appellate judge. That was our office, and my desk was right there among everybody. Little baby lawyer coming out of law school, getting your first job, getting this huge job. Against all the people that went to Harvard and Yale, and I went to Rutgers Law School, and there was one of the judges, the appellate judges, came in one night to talk to my judge and said, look at this case I have, Michael. Look at this case I have. It's a simple traffic stop, and it's an issue about whether there's going to be, quote, an omission that comes in. And what happened is that this man was convicted, and they ended up reversing it. And here's why. Police stop somebody. Tail light is out. The police officer walks the car. No one ran. The police officer walks the car and says, sir, license and registration. And he said, why am I being stopped? He said, because your tail light is out. Now, the transcript just says it was. A dry transcript, it was. However, as the judge pointed out, did he say it was? Question mark. Or was it an admission? It was. So based on it got reversed because there was no indication. The prosecution argued that has to be an admission. How could it? It doesn't have to be an admission because it could be. It was. And so
That's
you
very
have
interesting.
and that was a lesson for me. And the judge said to me that you can look at the transcripts, but the words don't necessarily mean it's what you're seeing, what you're hearing. And I bring that lesson to all of you because it was one of my very first lessons with a Supreme Court justice, another appellate judge, and my judge, who was the head of the whole appellate judge, who I was clerking for. And they came into conferences to see what they were going to do with it, what kind of deference they had to give to the trial court.
I think it's interesting to know what the transcription process was because, as you know, I used to be intimate with a court reporter. We were married at
Well,
the
she
time.
was your first wife.
Yes, she
It
was.
was her first wife. I mean,
And,
we don't want to start
so
like rumors here
I
and get
got
you
to know
booted.
all about that machine and the process and my my appreciation for court reporters, who I still say are the most important person in the room because they're making the record. But they are required to interpret that audio as a question, as a statement. They have to do that. So I'm curious, in this situation, who was transcribing that
It was a court
conversation?
reporter. They never went back to the court reporter because it wasn't in the record as to what the transcript, and it didn't have anything. It just had it was. It didn't have
Yeah,
a question
that's
mark. It didn't have a period. It just had it was.
yeah.
Because they had machines too in New Jersey. They type, and then it goes into these little machines that has like stuff that you and I can't read, right? It
Well, yeah,
could be
that's normal.
the alien.
Court reporter. That's normal. It has like 10 characters, and that's all. But
Right,
it's a
right.
series of fingers, and I know that
Like,
FPLT. That's period. When you end a sentence, it's like
really?
it's like 4 strokes. They just straight down, and it comes out FPLT, and that's
Oh,
period.
wow. It's like
So
talking Martian. Oh, yeah,
yeah, it is. It's amazing, and they have to
it's
do it at like
amazing.
200
So
plus words a minute.
therefore it could be anything, right? It could
Yeah,
be
no, I think
you and
that's a
I
good
can
lesson.
interpret it.
Yep,
But
and that's
it was one of my early lessons, and I have never forgotten it. So when you say, they want to look at the notes for some kind of question. And you're absolutely right. If there is an admission, which I doubt, by the time Karen Reed did this interview, remember she did she did Vanity Fair, right?
Yep.
She's already
She
been on
wasn't shy.
trial, right? She has really a great attorneys. I tried the Phil Spector hung jury that I got against Alan Jackson, who is, by the way, I learned that he initially had the ASAP Rocky case, just so you know. He was in it for a brief second.
Yeah.
But then there was some conflicts in terms of scheduling and all. And all. So yeah, so what you're talking about is, so what do you, if there is, quote, you know, mission, isn't that the interviewer's interpretation? Excuse me
Well,
while I'm
yeah,
going
and
off camera.
well, that's what's going to happen is you're going to have, if there is something that
Sorry.
passes all of these tests. Are you back? If you have something that passes all these
I've
tests
never
that
left.
allows it to be admitted, you're going to have her testimony not just to lay the foundation for the material, but to interpret it. When you make a note that says she hit him, what was the context? What was the intonation?
Oops, sorry.
If that note exists, she's going to have to testify, and she's obviously, I've got here, I've been looking at her second amended affidavit here, a declaration we would call it in many states.
Yeah,
It's
we
a
call
sworn
it
statement.
certification. We call it
You-
certification in Jersey.
in
Yes,
Jersey, yeah, I
that's
think
right.
it's a declaration in most states, California included. And in here she is pointing out that this puts her in a horrible position. Remember, there are only I think it's 5 or 6 states that have no reporters shield law, and that's what this boils down to. The judge has great latitude in weighing, the interest of justice in making the reporter cough up the notes. Now, remember, it's not the source, which would be much better protected. The person. Well, clearly, there's no source issue here. We know it's Karen Reed. So
Yeah.
this is all about weighing the interest of the privacy in this reporter's notes and the impact it might have on her ability to be, trusted, or to do her job, stealthily, or gain the belief somebody she's going after, that they can trust her. Well, here's my answer to that. You go to a state like Massachusetts, even if it's the Boston Magazine, you get what you get. There's no surprise there. You have zero protection. You need to know that going in. And if you go in with that wide open perspective, you have to realize that every conversation you have, unless there's a source issue, your notes are going to be fair game. So
It's
that's why I think this
interesting
argument's
though,
going to fall
right?
flat.
It's
Oh, I
interesting
think it's
because
very, I
let's
don't
go
like it.
back.
I hate it. I think
Is
it's
it
ridiculous.
because when you talk about it, now I come from a state that has an incredible shield law. I think I mentioned on a previous show, the strongest shield law that exists in the United States, and that's New Jersey. And it arose out of a case called Dr. X, and you could Google it. Dr. Yaskalovich, who was charged with a number of counts of murder in a hospital.
Is it a
And
mob
the
case?
New York Times, no, New York,
Oh,
it
okay.
was a doctor who was killing people in hospitals because he was killing according to the state, he was killing the other doctor's patients right away so that he would be the highest doctor there. He was acquitted in a very long trial that ran in a county, Essex County, New Jersey. But it ended up resulting in, because the prosecutor wanted the notes from the New York Times reporter. And it went all the way up to the New Jersey Supreme Court, and they ruled you get nothing. You don't get notes. You don't get interviews. You don't even get it in New Jersey if it's published. If somebody's in jail for murder and says to a reporter, "Yes, I did it," and that that sounds like a title of a book. All right, and you put it in the front page of the local paper. You can't get that in as an admission. You get nothing. It is so strong. And what people don't realize, all these privileges you and I talk about, they're not generally constitutional privilege. They're created by court rule. They're created by
Statute.
possibly a statute. And now, with the way the Constitution is being interpreted, I'm not sure, because this could go up to the U.S. Supreme Court, right, under the basis that there's a constitutional privilege if she chooses, if Ms. Voss chooses. I don't know if that Supreme Court, given its makeup right now, would find that there is a constitutional privilege in a reporter's
I'm
notes.
not sure. That'd be interesting to see if they would even take it, because
Right.
you've got a situation in which a very tiny number of states have no protection and 45 or so have protection. It's not truly an issue in dispute like most would be, but it'd be interesting.
Yeah, no, but it'd be really interesting because people just assume that husband, wife. Oh yeah, a husband, wife privilege. Oh, it's created by either statute or a court rule, right? It's not there. Federal privileges, like, and when you go to a counselor, your federal privileges don't exist unless they're in the federal rules, right? In the rules of evidence. But sometimes you'll have a code. So, for instance, if somebody will get federal money, a drug treatment will get situation, a drug treatment facility will get federal money. Then in the federal code that you have, and then not the law code, the code applying to administrative situations, there'll be an issue that if they get funds as privileges. And if they don't, there are no privileges. And people don't realize that privilege is a very complex situation. It's not like what you say is privileged all the time. It's not.
Yeah. And we'll find, and I think Judge Bev will be working with this concept, common law. I think most people realize you have statutory law. Common law is law that evolves out of case law. And so she can rely on that and use that in her weighing process. It's far more, I like to call it rubber. It's kind of harder to
Right.
get your hands around, but it is legitimate. And if she can find the right analysis and the right precedents, it'll work. Here's a couple of statements from Ms. Voss's affidavit.
You have her
She goes,
affidavit?
I have her affidavit, the second one. They amended it slightly. I don't believe there is anything contained in my notes of the off-the-record meeting with Miss Reed that would be of value to the Commonwealth in this case. The information I obtained is not central to the Commonwealth's prosecution of Miss Reed. Well, thank you, counselor. Thank you for making it so easy for us to just figure the notes are useless.